Hi, I'm Madeline Sawyer, and I practice family law at Cannon and Associates. What is an emergency custody order? How do you get one? How do you fight one? In this video, I'm going to be discussing the ins and outs of emergency custody orders. What is an emergency custody order? An emergency custody order is a temporary order awarding custody to one party when a child is subject to irreparable harm. Sometimes these are talked about in the context of DHS emergency custody orders. Today, we're only talking about when one parent is alleging that the child is subject to irreparable harm while in the custody of the other parent. How do you get an emergency custody order? There's two ways that you can get an emergency custody order. You can file an application for a temporary restraining order or an application for an emergency order. And then once the application is filed, the judge has the authority to issue what's called an ex parte order. And the ex parte just means that both parties to the action aren't present. So usually just one party is there, and that's the party that's asking for the emergency order or the temporary restraining order. What are the requirements for an ex parte order? Oklahoma statute requires an independent report if one is available from law enforcement agency or from DHS that demonstrates the child is in surroundings which endanger the safety of that child, and if such conditions continue, the child will be subject to irreparable harm. If one of those independent reports are not available, the court allows for an affidavit by a party who has firsthand knowledge of those same circumstances. So in the event that a parent alleges that a child is subject to irreparable harm, but maybe something has happened and the police report or the DHS report isn't available yet because those things aren't written right away, or they're not available right away, the parent can sign an affidavit saying that these things happened and these circumstances or conditions exist. And that is sufficient for an application for an emergency order or TRO. After an emergency custody order is granted, the court will hold a show cause hearing. That hearing usually happens within either 3 days or 10 days of the ex parte order. And at that hearing, both parties argue whether the standard has been met to continue that order. The burden is on the party asking for the ex parte order to show that irreparable harm will occur if no order is issued. So if they're basically saying that if that ex parte order isn't continued, then the child will suffer irreparable harm. And what constitutes irreparable harm is very much dependent upon which judge you're in front of. So it's really important to have an attorney who has knowledge and experience with each particular judge and what their perception of irreparable harm is. I'm Madeline Sawyer, fierce advocate for families. If you or a loved one are facing a custody dispute or emergency custody, call us or reach out through our website.